See, there is a prescribed limit for filing any document in law, be it a suit or a written statement or an appeal or a revision. And if it is not filed in the prescribed limit, Section 5 of Limitation Act comes into play, which talks about condonation of delay and extension of period if there is a sufficient cause with the party. So if the party cannot prove that there was a sufficient cause, even a delay of few days will not be condoned by the court. And if the party proves that there was a sufficient cause with him, then the delay of about 28 years will also be condoned, which I will let you know after in this video. So that is the importance of the term sufficient cause. But the problem lies here is this term sufficient cause is not defined anywhere in the Limitation Act. So it takes practically years for the court to decide whether the cause stated by the party is a sufficient cause or not. So let us try to understand with various rulings what is the concept of this sufficient cause and how to condone the delay. So the basic concept says that when the cause is not in the control and beyond the control of the invoking party, then that cause is a sufficient cause. It means the party himself should not be negligent, party himself should not acted in the bad faith before the court. This the court will ascertain. This principle was laid down back in 1889 by the Privy Council in the case of Krishna versus Chattappam. Then in 1972, Supreme Court in the case of State of West Bengal versus Howrah Municipality laid that for the advancement of justice, court should liberally interpret the word sufficient cause. And to continue it, Supreme Court in another case, Veda Vai versus Shantaram Patel, said that this phrase, every day's delay, should be understood in a very practical sense. Now, a very important Supreme Court ruling, Collector Land Acquisition versus Katiji. This ruling is referred in various other Supreme Court rulings where they are talking about the concept of condonation of delay. It said that the judiciary, the courts, are respected because of their capability of removing the injustice and not for the legalizing injustice on the ground that they are limitation time but therefore the meritorious case should be thrown out. No. Even if a document is limitation time barred, then also if the case is meritorious, then the delay must be condoned. This Supreme Court laid down in this ruling. Now the question arises, why it happens that courts do not condone the delay of merely a few days and condones the delay of 21 years and 28 years delay? A major mistake which the litigants do that if there is some delay, they take it very casually, and the application of condonation of delay application which they make is also very casual in manner. They just mention that they have bona fide reasons or they were facing severe problems making it impossible to file on time. So for justice it should be condoned. No, this doesn't work. They have to mention that what exactly caused the delay in filing. The application must be precise and clear so that the judge can also ascertain the reasonability and the sufficiency of the cause. It should not be vague and ambiguous. So now we will see various Supreme Court rulings in which it condoned the delay. In 2024, Supreme Court in the case of Moolchand versus Union of India condoned 425 days of delay because of the sufficient cause that the advocate, the counsel in the court below was negligent, and the mistake of the counsel should not be attributed as the mistake of the party. Now a 21-year delay was condoned in a 2024 Supreme Court ruling in Urban Improvement Trust versus Vidya Devi, being it an exceptional case as the action was patently illegal and against the fundamental rights. Supreme Court held that if there is a right to property, that right cannot be brushed aside mere on the technical grounds of limitation. Therefore, it condoned the delay of 21 years in that case. Then a delay of 28 years condoned by Supreme Court in Nand Kishore versus State of Punjab in the year 1995. Because Supreme Court found that the appellant was fighting all those years in different forums. And one of the forum which took a lot of time was actually the wrong forum. So Supreme Court, for advancing the justice, advised the appellant the correct remedy, also allowed him to file the SLP after the period of 28 years. So this case is an exceptional case where the 28 year is condoned. So in conclusion, as we can see that this provision of condonation of delay section 5 is just a one paragraph long, very short law, but the discussion on the same has become endless. Because there is no exhaustive test laid down on the same by the Supreme Court, neither it has been defined anywhere. So it becomes very important for the advocates to present the facts in such a way before the court that court also gets convinced that the cause laid down is a sufficient cause and ultimately condones the delay. So in the end, I want your opinion on one question. According to you, if a document is filed after the prescribed limitation period, so should the court reject it solely on the ground that it is limitation time barred? Or should the court examine the merits of the case and accept the delayed document even after it has been filed after the prescribed limitation period? Now for this, I will wait for your opinion in the comment box. Thank you.